And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The headline hit the internet like a bomb. Supreme Court 8-1 decision changed the First and Second Amendments. But if you repeat the viral, oversimplified version of that story, you could be risking your rights instead of protecting them. Why? Because the internet has conflated two separate massive legal moments into one confusing mess. The core decision, United States versus Rahimi, came down overwhelmingly 8-1. It held that the federal government can temporarily prohibit an individual from possessing firearms if that person is currently subject to a domestic violence restraining order, and a court has specifically found that person is a credible physical threat to the safety of another individual. That is the narrow, precise ruling. The Second Amendment right to keep and bear arms is not violated by that temporary, targeted restriction. Now, that decision by itself is huge, but to understand why people are attaching the First Amendment to it, you have to realize what Rahimi also did. It fundamentally clarified how all courts must now judge all future gun laws. And that clarification involves free speech. The most critical takeaway from Rahimi isn't just about restraining orders, it's about the standard known as Bruin. If you follow gun rights, you know Bruin told courts they must judge modern gun restrictions based on historical tradition, not modern policy balancing. After Bruin, lower courts devolved into chaos. Some judges began acting like the government had to find an exact word-for-word copy of a law from 1791 to justify any modern regulation, like demanding a historical twin. The Supreme Court in Rahimi stepped in and effectively said, "Stop that." They explained the Second Amendment is not frozen like a fly in amber. You don't need a perfect historical twin, you need a historical analog. An analog just means it's close enough in the key respects. The key questions courts must ask now are, why did the law exist historically? What problem was it trying to stop? And how does the modern law compare in terms of how heavily it burdens the right? That shift from demanding a twin to accepting an analog is massive. It affects every single law restricting carry, banning certain firearms, or establishing sensitive zones. If you want to understand how this clarification will impact carry zones and permitting rules next year, hit that like button and subscribe to Law Advisor right now. Let's dive deeper into the 8-1 result. The man in this case, Rahimi, was challenging the law, a federal ban on gun possession for those under certain DVROs, as unconstitutional on its face. He wasn't saying the law was applied wrongly in his specific situation. He was saying the law was always invalid, no matter who you were or what the circumstances were. That is the hardest kind of constitutional challenge to win, because you have to prove the law could never be constitutional. The court rejected that argument. The majority explained that, historically, English and early American law always provided mechanisms to disarm people who had demonstrably threatened others with violence or were shown to be a danger to the public peace. The court reasoned that disarming someone who has already been found, through a due process procedure, to be a credible physical threat fits squarely within that tradition. Crucially, the court did not say that anyone accused of something loses their rights. This decision hinges on the fact that a judge, in a specific proceeding, had made a finding that Rahimi was a credible threat to the physical safety of another person. That finding, that judicial determination of danger, is the trigger. That detail matters everything if you care about due process, because it prevents the government from just slapping a random, dangerous label on anyone it dislikes. So where does the First Amendment fit into this narrative? It's not because Rahimi was a speech case. It wasn't. The First Amendment element comes from a separate but equally important legal fight that targets gun owners and advocates in a different way. The First Amendment issue centers on government coercion. It asks, can government officials use their regulatory power to quietly pressure private companies, like banks, payment processors, or insurers, into refusing service or punishing the lawful speech of groups the government disagrees with? This often hits gun advocacy groups, instructors, or retailers. In real life, the fastest way to destroy a controversial group is not always to pass a law outlawing it. It's often easier to cut off its financial lifeline, stopping its banking, removing its payment platforms, or stripping its insurance. If government officials suggest to regulated industries that they should stop doing business with certain speakers while waiving the implicit threat of investigations or enforcement actions, that becomes a backdoor way to silence speech without ever passing a law. That is a First Amendment violation, often called the quiet squeeze. Gun owners should care deeply about this. The debate over the Second Amendment is only possible because of the First Amendment. If you can't speak, you can't organize. If you can't organize, you can't fund lawsuits like Bruin or Rahimi. If the government can use backdoor coercion to silence lawful gun speech, the Second Amendment right loses its engine. That's why the headline says both amendments changed. The court clarified the limits of the Second Amendment in targeted cases of physical threat, and simultaneously reinforced the limits of government power to suppress speech under the First Amendment. Let's make this practical with 3 scenarios, because the law lives in the details. Scenario 1, the messy breakup. Imagine a guy named Mike is going through a nasty split. He legally owns firearms. His ex-partner files for a protective order. Mike thinks, this is just family court drama. It's civil. It'll blow over. That is the most dangerous mistake a gun owner can make. If that protective order, or restraining order, contains specific findings that Mike poses a credible threat to physical safety, even if the underlying act wasn't a criminal conviction, Mike can suddenly be in federal felony territory just for possessing a firearm while the order is active. Temporary can still mean handcuffs. Temporary can still mean thousands in legal fees. You must treat any proceeding involving threats or violence as if your future freedom depends on it, because it does. Scenario 2, the quiet squeeze. Imagine you run a business selling perfectly legal gun parts, or you teach safety courses. You're not doing anything wrong. Then suddenly your bank closes your account, or your payment processor, without warning, says you violate their terms of service. You ask why, and the answers are vague. This is the reality of the First Amendment pressure fight. It demonstrates that even if no new gun law is passed, government coercion aimed at financial institutions can make it nearly impossible for lawful gun-related businesses or speech to survive. Scenario 3, the traffic stop. You are pulled over. You are nervous. You have a legally stored firearm. You start over-explaining, reaching for papers, and talking too fast. Your words are your First Amendment in action. Your firearm is your Second Amendment reality. The worst thing you can do is panic and create suspicion where none existed. Understanding your rights isn't about acting tough, it's about acting smart. The law advisor philosophy is always the same. Cooperate calmly, but know your limits and don't create unnecessary probable cause through excessive speech or motion. A lot of gun owners lose rights without ever committing a gun crime. They lose rights because of paperwork, because they ignored a hearing, because they assumed civil means safe. Don't fall for that myth. Let's address the biggest myth circulating about Rahimi. People keep saying, so this means if someone gets accused, they lose guns. No, accusation is not the standard. The decision is grounded in a court finding tied to a credible threat and structured with procedural requirements. The system is supposed to give notice and a chance to respond before the restriction kicks in. That is the core due process element that kept the law constitutional here. Another myth is that the court just created a blank check where the government can label anyone dangerous and take their rights. Absolutely not. The court specifically rejected the idea of using sloppy, overly broad labels. It focused intensely on the historical tradition of disarming those who had demonstrated their danger, requiring a specific, targeted finding, not just an assumption. Rahimi does not erase Bruin. It tells courts how to apply Bruin correctly. It tells judges to stop demanding impossible historical perfection. This will be cited in every major Second Amendment case moving forward, forcing courts to ask, is the modern law narrowly tailored and tied to a specific danger, or is it broad and based on arbitrary category labels? If you are a gun owner, you have to be the most boring, careful person in the room when conflict starts, not because you are weak, but because you have more to lose. The law is not forgiving when firearms are involved. A small mistake is treated like a large one. If you only remember one thing from this entire video, remember this. Most people don't lose rights in a dramatic scene. They lose rights in boring moments, a court date they skipped, a form they didn't read, a message they should have never sent, or a restraining order they assumed wasn't serious. The law does not care that you are normally a good person. The law cares about what's written, what's filed, what's ordered, and what you did next. If you are currently under any kind of protective order, your action is simple. Read it carefully, follow it strictly, and talk to a lawyer in your area immediately about the firearm implications. If someone is threatening to file an order against you, your action is stop all communication, don't send angry texts, don't escalate, and get real legal counsel now. If you run a gun-related business, understand that First Amendment protections against government pressure matter more now than ever. Rahimi is not the end of the Second Amendment, but it is a major signal flare about how the Supreme Court expects future cases to be adjudicated. When you combine that with First Amendment warnings against government suppression of speech, you see the bigger message from Law Advisor. Rights are real, but they come with rules, and government power has limits, but you need to know exactly where those limits are. Here is the last warning, stated as plainly as possible. Do not assume you are safe because you have never been convicted of a crime. Federal law can apply to people who have never been convicted of anything if they are under a qualifying court order, and they possess firearms anyway. That's why precision and awareness matter. You can't treat this like internet gossip. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, Knowledge is the ultimate defense. I will see you in the next one.